docket, which is case number 110853, State of Kansas v. Lewis.
May it please the court, Peter Meharry for Stephen Lewis. I would request 3 minutes of my time for rebuttal.
3 minutes is granted.
This case, again, is a felony murder case that comes before the court arising out of what turned out to be some gang violence down in Wichita. My client, Mr. Lewis, was convicted of felony murder in addition to 3 counts of attempted first-degree murder, 3 counts of ag assault, 3 counts of criminal discharge at a vehicle, and 2 counts of criminal discharge at a house. He was sentenced to life without parole for 25 years plus 165 months incarceration. We've raised several issues in our brief, and if I could just start with issue number 1, which deals with the lesser included offenses. In this case, at trial, defense counsel requested several lessers with regard to the 3 counts of attempted first-degree murder, 2 of which arose from the shootings that took place at the restaurant, and the 3rd arose from the shooting that took place at the house. With regard to the ones that took place at the restaurant, the district court did instruct on the main charge, which was attempted first-degree murder. It also instructed on attempted second-degree and attempted voluntary manslaughter. In addition, defense counsel asked for the district court to instruct on the lesser included offense of attempted involuntary manslaughter. It's our position that that was both legally and factually appropriate in this case.
What are the facts that you can cite to that would reasonably justify a conviction?
As far as
I understand the legal, but what factually is there?
I think certainly shooting at an occupied car could be viewed as reckless conduct. Certainly, if there is no, the state certainly argued that there was an intent to kill here, but I think there was evidence that maybe he was firing in response, or this was basically mutual combat where he was just shooting. So I think you could look at shooting at a car with individuals involved inside that car to be reckless conduct, to ignore a substantial risk of obviously somebody getting severely hurt.
Does the premeditation have to be person specific? My understanding is we have, or the theory was 2 rival gangs, and one gang made its get away from the restaurant, and the other gang followed, including defendant, and shot at one of the cars that had left the restaurant. And is it enough to prove premeditation if they prove that they were shooting at the car with intent to kill a rival gang member without knowing who's in the car? You follow what I'm saying? Did they? Yeah. I think it was Ma was the victim here. Did they have to premeditate killing her, or just a member of that gang?
I think, and I could be wrong on this, but I think they instructed that it had to be specific to a person, to attempt to kill the name. And I would argue that I think you should have to prove that if you have specific intent to kill someone, that should be, it would seem to me that would be person specific. In this case, I think certainly the state would probably argue, and probably did, that there was intent to kill the occupants of the vehicle. And that is why that my client shot at the vehicle. And I think that is person specific in that there are specific persons getting into that vehicle. So I think as far as proof of premeditation or attempt or specific intent to kill specific people, I think the state should have to prove that. And I think, like I said, I think the instructions did require that, but I'd have to double check on that, Your Honor. So when you have evidence of, at least evidence to support a crime of attempted first-degree murder, we believe that there is certainly evidence to support the lesser-included offense of attempted involuntary manslaughter. We believe it's one of the situations where when you prove the greater, you've necessarily proved the lesser. And one of the things I would point out, as far as this court back in the 90s said that there was no such thing as attempted involuntary manslaughter. I think with the changes made in recodification, which now says that if you have proven intentional conduct, you have proven reckless conduct. So one necessarily proves the other. Intentional conduct necessarily proves reckless conduct. That change would allow for this crime to be recognized by the state of Kansas. And further, the evidence to support the intentional act also supports reckless. So we believe that it was factually and legally appropriate and should have been given in this case. The other one that was requested was attempted second-degree murder. And this deals with the drive-by shooting at the residence. We believe that factually and legally this is appropriate, and we believe that district court erred when it ruled that it was not going to instruct on attempted second degree because it found that the driving from the restaurant to the house, which took anywhere from 6 to 8 minutes, shows premeditation. We think that is a district court making what we believe is a factual finding. While that may be evidence of premeditation, that is evidence for the jury to consider in whether or not there is premeditation. And certainly we believe that if you prove attempted first degree, you've proven premeditation, you've proven intent to kill. All attempted second degree is an intentional killing. So that is necessarily proven, and that should have been given as well.
Is that our criteria that it's necessarily proven?
I don't think that language, I could point to a case that has that language in it, but I think that this court has talked about when you prove a greater crime, where you have first-degree murder, you have premeditation, intentional killing. Second-degree murder is simply intentional killing. By proving both of the elements of premeditated murder, you have necessarily proven the element for second-degree murder. So I think when you look at it that way, when you're just adding an element to go up a level in the crime, you have necessarily proven that lesser included offense.
So the extension of that would be that there's no gatekeeping role by the court at all. The court just gives all lesser included instructions in all cases.
I believe the court, if there is some evidence.
If there's an identity of elements in the lessers.
Correct. I believe that the court should give all lessers in these situations.
But is that consistent with our case law? Haven't we had cases where we have recognized that a judge is more of a gatekeeper in that, and if the evidence of premeditation is so strong that it's not reasonably likely that the jury would convict of the lesser, we've affirmed that?
I think that
without even getting to a harmlessness. I'm talking about back here at the
I guess I see that as
stage.
I'm sorry. I see that as going to the harmless error question. But at the outset, whether or not it's legally appropriate, I don't think the court does act as a gatekeeper because it has to determine that there is some evidence. Per the statute, it has to find some evidence to support the lesser included. That is a very low bar in our opinion. And certainly I think when you have evidence of the greater, you necessarily have evidence of the lesser. And the court shall instruct on those lessers when there is some evidence. So I think while there is some role of gatekeeper, it is a very low bar in that all it has to find is some evidence of that lesser.
Isn't the statutory language some evidence that would reasonably justify a jury in convicting on that lesser?
It is.
And so wouldn't one interpretation of that statute be that it requires more than some evidence? It's some evidence that would reasonably justify a conviction, and if in fact the evidence of the greater is overwhelming, it may not reasonably justify a conviction on the lesser.
I disagree with that interpretation.
Why? And I understand that you do, but can you articulate why that interpretation is not a correct way to read that statute?
When you look at whether or not there's some evidence that a reasonable jury could convict on, I think you are looking at the outset, essentially a sufficiency view. And in this case, if the jury would have come back with attempted second-degree murder, nobody here would be saying the jury was unreasonable, because there is clear evidence to support that. And whether or not there is more evidence, I don't think
So
changes
your
that
argument is
evaluation.
that phrase in the statute, reasonably justify, is identical in meaning to would be sufficient.
I believe so, Your Honor. I think when you look at what the jury, or what the standards are for instructing the jury on lessers, you look at, is there some evidence that would support that conviction? And that is a very low bar in our opinion, and requires the district courts to give those lessers, such as in this case.
And so if there is evidence that would reasonably justify conviction of first-degree murder, it automatically means you would get an instruction for second-degree intentional, correct?
I would argue yes, Your Honor. I think that is what the statute contemplates, and that's what the statute directs. It
And
uses,
the same thing for something like an aggravated crime and then the simple crime itself.
I would agree with that as well, Your Honor. You look, again, going back to the statute, it talks about some evidence that would reasonably support a conviction. And if you have evidence to prove ag burglary, you have evidence to prove burglary. If you have evidence to prove first...
Even though in your ag burglary scenario, there's no question that the dwelling was occupied. Not a question. You'd still give a burglary instruction.
I would, Your Honor. And I would submit that even if the evidence is completely overwhelming, that the residence was
Or say in an
occupied...
ag robbery, there's no question that a gun was used or firearm was used. You would still give a robbery, and I'm having why? What would reasonably justify a conviction for robbery? And I know we're switching here from first and second degree, but in that, what would reasonably justify a conviction of robbery in that scenario when, let's say the victim was shot? There's no question that
Right.
a firearm was used. Why is that reasonable?
A couple things, Your Honor. Number one is, even if there's overwhelming evidence that a weapon was used, we still put that in the instructions. We still require the jury to find that. Secondly, a jury could say, you know what, there was a gun there. I'm not convicting of ag robbery. I'll give robbery. For whatever reason. We allow jury nullification. We don't instruct on it, but we do allow it. And even when...
And so what you're saying is, even if there's overwhelming evidence, it's still a jury question.
That's exactly right, Your Honor.
And Section 5 of the Kansas Bill of Rights says the right of trial by jury shall be inviolate. And so your argument is that the gatekeeping is taken away from the jury.
Yes, these are questions that we put to a jury, even if we sit here and say this is overwhelming evidence.
Well, then
It-
why
I
do
mean,
we
we-
why do we have a statute about lesser included instructions of that? Why is that there? What role does the court play? It just seems to me that you just always give lessers under your reading of it, and from the top to the bottom.
And again, I think that is what the court should do. They should look at to determine whether or not there is some evidence. That's the role of the court. And I think that, again, is a very low bar. But I think we instruct on all these elements, whether or not they're proven beyond all doubt or not. We require a jury to find these things take place, in this case, in Sedgwick County. There's never any argument that it wasn't, but we still put that as an element because that is a factual finding that we have the jury do. And so we think that when you have the greater, when you have evidence of the greater, you have necessarily proven evidence of the lesser. And it's the jury's determination as to what the conviction should be.
And is that true as a matter of law? In other words, that there's no discretion in the district court. The lessers have to be given. And where I'm leading with that question is there are scenarios in which defendants seek an all or nothing defense, and the defendant himself may not want the lesser, may affirmatively say, I don't want a lesser. Does it still have to be given because of the way you interpret the statute is that it's a shall, no discretion has to be given?
I think if a defendant affirmatively states, no, I just want first degree murder, I think that's a different scenario.
But why? Why is it different when the district court has no discretion under your perspective?
Because I think the defendant can waive those essentially statutory rights to lesser included offenses.
Can the defendant concede a legal error? We say no usually. Would we call that invited error on the part of the defendant? Once it gets to appeal and the
If the
appellate
def-
lawyer wants to argue that, I
Yeah.
mean, you see, if it's,
I mean, if the defendant gets up in court and says, Your Honor, I want no lessers. My defense is, I didn't do this. I don't want to give the jury options. I want all or nothing. If the jury comes back and convicts, he appeals. I think as far as any appellate issues, in that hypothetical, we may be looking at certainly invited error. Because you are specifically asking the court to do something, and the court followed your wish. I would argue, obviously, that that is not the situation we have here. Defense counsel did request these lessers, and they are legally and factually appropriate in this case, and they should have been given. If there are no other questions, I would submit the remaining issues on the brief and ask that you reverse for those reasons.
Any more questions? Thank you, counsel.
If it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I will also focus on the lesser included issue and be happy to take any questions on the remaining issues.
Mr. Maloney,
Sure.
we've had this lesser included offense issue bubbling around here for quite a long time, as you're well aware. Has there been any effort, obviously this is outside the record, but I'm curious, I know that sometimes the District and County Attorneys Association will advocate for certain statutory change in the legislature. Has there been any effort to amend the statute in the recent past?
I am not aware specifically of an effort to amend that particular statute. Now, that's not to say that it hasn't happened without
Okay.
my knowledge.
I'm
but
just asking about your knowledge. So.
Yeah, I'm not that I am specifically aware of. I don't know that that is one that we have sought to change, and I would surmise that the reason that we might not have would be consistent with the same argument that I've made repeatedly. And I think that and Your Honor was pointing this out, I think that the language of the current statute is sufficient to address the concern or to address the issue raised today, and that is with the inclusion of the word reasonably in the statute. And
So the district judge has a gatekeeping function.
Exactly. And I fully appreciate and agree with the importance of a defendant's right to a jury trial, and I would never suggest otherwise. But I think that not only in this context, speaking of instructions, but in numerous contexts within that right to a jury trial, the judge does still play an important gatekeeping role in the trial. And here...
Haven't we said that it was error for the district court to instruct a jury that an element has been met? For instance, that a through and through gunshot wound is great bodily harm as a matter of law. Haven't we said that it's wrong for a judge to tell the jury that the evidence has established an element?
Yes, you have.
And why isn't saying refusing to give a second degree a court-found element of premeditation? The court has said the evidence, as I have heard it, establishes beyond a reasonable doubt premeditation, so that second degree is not appropriate. You can call it gatekeeping, but ultimately it's the judge making the determination that the evidence has established beyond a reasonable doubt an element of the crime. Is it not?
I would disagree. The jury could have acquitted this man. If the jury didn't think that there was premeditation, they could have acquitted him. If the jury, when the judge in the cases you're talking about, when the judge flat out says that an element is met, that really takes it out of the jury's hands. Here it doesn't.
And along those lines, where does the right to a lesser included instruction come from? Does it derive from the statute, or does it derive from the constitutional right to trial by jury?
The case law, with respect to the standard of review, has indicated that it is statutory, because I believe all the cases in which this has been analyzed, when they get, if it gets to a harmless error analysis, always uses the statutory.
So if the legislature were to just repeal the lesser included statute, then from that point forward, defendants go to the jury on the charged crime only. They don't have a, or at least the presumption would be that they don't have, or we haven't, this court hasn't found a constitutional right to lesser included instructions. Is that what you're saying?
I think that would be consistent with what the case law has been to this point. Now, obviously, if that were to happen, which I certainly don't envision the legislature ever doing, but if that were, then I'm certain that the defendants would then strongly push for a constitutional right. But to date, I believe it has been consistently analyzed under just the statutory test.
That's the whole
Mr.
lessers of a felony line. The recent line on lessers of felony, the legislature abolished the lessers of felony.
Exactly.
They were statutory.
Mr. Maloney, did your career span long enough to remember Fike?
Yes, sadly, it's long enough to remember most cases these days. I came in right around the time Fike was. I know it was around that time where Fike was first being discussed.
Is your memory fuzzy of that, or do you remember the legislative history of the amendments to repeal this court's test in Fike?
I think fuzzy would probably be a fairly fair word to use for that. Yes.
Is it fuzzy? Is your fuzzy recollection such that it seems to me that the defendant's arguments today are putting us back in Fike land, the third prong of Fike. Is that kind of what you had as you would remember it?
I don't specific. I think that does sound vaguely familiar, and I do think that essentially, as I read the brief and hear the defendant's argument, it essentially is requiring. I think the defendant would essentially just say that the judge has no role at all in this situation, that the judge, everything goes, and that essentially what he's arguing is that this court's analysis, where you first look to whether an instruction is legally appropriate and then whether it's factually appropriate, in order to agree with the defendant's argument, you would have to just completely eliminate that factual appropriate inquiry. It would solely be, is it a lesser included offense legally speaking? And if yes, then you have to give the instruction. It doesn't matter what the facts of a particular case are. It doesn't matter whether in this case or in any other case the evidence is not even contested on one of the elements. That if it is by law a lesser included, so any that's a lesser degree of the same crime, you just have to give it. And I think Your Honors used some.
I don't think that's what's being said. The gatekeeping is the evidence sufficient to reasonably justify a conviction on the lesser? Have all the elements of the lesser, not the fact that it is a lesser included offense, but has the evidence in this case proved the lesser included offense?
And I would argue again, as I have so many times, I think that to accept that argument, you would have to just be taking a pen and striking the word reasonably out of that statute. And I think that that's what that means in this context, is that in order for it to be appropriate, it has to not just simply be something where we can say, well, if the jury for some reason had found that, we wouldn't overturn it for insufficient evidence. I think those are two very different standards. And a lot of times in these cases, that's what the defense tries to argue as well. If in this case,
what do we look at when we look at the sufficiency of the evidence? What a jury would rationally decide, and what's the difference between rationally deciding and reasonably deciding?
Well, again, I would argue that they're not the same. I think when you're looking at the sufficiency of the evidence, if it's a case where the court had given an instruction and the defense were then tried to challenge it on appeal, then of course in that aspect the standard review is in the light most favorable to the state, and the defendant would have a very high hurdle to overcome in trying to say that his conviction should be reversed for a lack of sufficient evidence. Here, we're not talking about a sufficiency argument. I know that the defense always tries to frame it as such and saying that that's why an instruction should be given, but here we are looking at this in the context of an instruction and whether it was factually and legally warranted. And I simply maintain that in a case such as this, it would not have been reasonable. And especially, I know there are a couple of different instructions that the defendant is talking about here. I'll jump to the attempted intentional second degree that he is requesting with respect to the shots fired at Jennifer Ma's vehicle. Of course, the only difference between the charged offense and the offense that he's requesting is the element of premeditation. So what we have in this case was a situation where the state presented overwhelming evidence of premeditation. The evidence is that this defendant had to drive 6 to 10 minutes from the site of the restaurant shooting to get to the neighborhood where he shot at this vehicle. He then fired multiple shots directly into the driver's side of the vehicle, and I think the evidence indicated that those shots, at least some of them, if not all, would have struck the driver had she not been able to duck down when she saw him coming. The evidence also shows that he had to reload his weapon during this drive-by shooting because the gun only held 15 rounds and he fired 18 shots. So we have overwhelming evidence of premeditation by the state. Meanwhile, the theory of defense was, I wasn't the guy. I didn't do this. I was not the one responsible for this drive-by shooting. So when we're looking at the question about whether the evidence would have reasonably justified a conviction on that, I don't think we can overlook the fact that the jury here had two options, essentially. The state's evidence of premeditation was overwhelming. The defendant's theory was that he didn't do this. So the jury's option in this case was to either convict as charged or to acquit him altogether because he was not the person that committed this crime. So our position would be in that situation, it's not reasonable. It would not have been reasonable for the jury to convict of a lesser included crime.
I'm going to pose the same question to you with regard to the specificity of the victim and premeditation. If this is a chase the gang members from the restaurant to a neighborhood and shoot at one of the cars, do you meet the premeditation element if you're just intending to shoot and kill all the other gang members and whoever may be in the car? Too bad, or did he have to premeditate killing her specifically?
Because the defendant didn't raise that particular issue, I didn't brush up on that as much as I should. My recollection is that it would apply regardless, even if he didn't specifically know that it was Jennifer Ma driving the vehicle. Even if he thought it was her boyfriend, who was the one who I believed owned that vehicle and had been driving it earlier in the night, I think that it could certainly be reasonably argued that he probably did think that it was her boyfriend that was driving the car. But my recollection of the case law on this would be the transferred intent that the state could still meet its premeditation burden even if the evidence showed that he was trying to kill or thought that he was shooting at one of the other gang members here. So my recollection would be that yes, we would be able to prove that element. I don't recall one way or the other whether the instructions specified that or informed the jury about the law of transferred intent. Of course, the record will show one way or the other on that, but I think just from a legal perspective that yes, the answer to your question is that that would be met if we could show that he was intending to kill or premeditating a killing of somebody else.
Let me ask you this. What's the harm of giving the lesser included offense instruction? If the evidence is so overwhelming, how's it going to hurt you?
I think that one way it would hurt is simply in every case then I think the potential for jury confusion or simply overwhelming the jury with numerous lesser included instructions simply muddies the waters. Again, I would argue that the judge, that is exactly what the judge is there to do, is to make these types of gatekeeping decisions, just as he or she does in the context of ruling on objections and evidentiary matters. There's simply so many instructions. Certain crimes have so many potential lesser included offenses that I think it would just simply confuse things and add unnecessary uncertainty into a trial when the evidence is very clear that a crime was either the charged offense or, in this case, nothing, because he again argued that he was not in any way responsible for the drive-by.
But on
Counsel
the flip
is-
side here, it wasn't given.
Excuse me?
On the flip side here, it wasn't given, or they weren't given, depending on the crimes you're talking about and the lessers sought. What's your harmlessness argument?
Well, with respect to the first one, attempted involuntary manslaughter, when he's arguing about the shooting at the restaurant, and I'm certainly not waiving the issue the argument I raised in the brief about why that's not legally appropriate, because that's not a recognized crime in Kansas. But with respect to that one, the harmless argument can rely on this court's discussion in State v. Plummer. Specifically, the jury was instructed on two lessers on that count, and that was attempted second-degree intentional and attempted voluntary manslaughter. And they rejected both of those, and by doing so, that shows conclusively that the jury found the element of premeditation beyond a reasonable doubt. So we can safely conclude that they would have rejected the still lesser crimes that were required of an involuntary action, because they've already shown by their verdict that they did find that this was a premeditated killing.
Counsel, can we look at whether this would be of any value in the discussion? A motion for a judgment of acquittal, often filed by defense counsel, and then the judge, as I understand it, serves as a gatekeeper to determine whether that case should go to the jury. And you made a comment earlier about the gatekeeping function of a judge on these lesser included offense instructions.
I think that's an excellent point. I think that is yet another way in which a trial judge's gatekeeping role has been consistently recognized throughout the years and approved of.
And what is the touchstone of that, exercising that gatekeeping function? The court has to decide whether there was sufficient evidence presented from which a rational jury could convict of the crime.
Right.
And that's the standard. But that standard doesn't apply to the gatekeeping of lesser included.
Well, again, I think it's tempting to compare a sufficiency of the evidence standard with an instructional request, but in order to do that, I think you would have to make a significant change to the law as it's existed for decades with respect to jury instructions.
And to pick up on Justice Biles' question on jury instructions, what is the harm if the judge always refuses the motion for judgment of acquittal? Let the jury sort it out.
Well, I don't know that the judge necessarily always...
Assuming the judge always did.
Well, in that case, again, you'd have... the judge would have to make the determination that there was sufficient evidence to support a conviction, and then the case would still go to the jury as to deciding whether the defendant was guilty of the charged offense or not. So I think I again fall back on that, is that this does not put the jury in a situation where they're just automatically forced to convict the defendant. This is not violating the defendant's right to a jury trial. Ultimately, it is the jury in these cases that makes the decision about whether a defendant is guilty. And so I think it's a real stretch for a defendant to argue otherwise and say that this is essentially taking the case away from the jury or not giving them the power to make the ultimate ruling in these cases. And
we do have case law out there. I'm looking at State v. Cordray, 277 Kansas 43, page 55, where we've said that neither case law or statutes support a determination that a criminal defendant has a right to an all-or-nothing defense. And so if the defendant doesn't have the right to reject lessers, why does the court have the right to reject it?
Well, I'd say that the defendant doesn't have a right to reject them if the evidence would reasonably justify a conviction with respect to them. And I would agree that the district court judge does not have that right either. If there is evidence that would reasonably justify a conviction of that, then the district court judge should give that instruction. And as a prosecutor, we never argue otherwise. We simply argue that the instruction should not be given when the evidence does not reasonably justify a conviction of that. And just briefly getting back to Your Honor's question, I think that with respect...
I was just going to redirect you.
Yeah, with respect to that second count that he's seeking the instruction on, it would just be, I think the harmless analysis there would be, the case law has talked about how this court should not speculate about hypothetical scenarios when you're trying to envision whether an instruction was warranted. And here I think this is kind of the textbook situation where that applies, because as I argued previously, you have the state's evidence overwhelming with respect to premeditation. The defendant's argument was that he didn't do this. So the only way that the jury could have convicted on a lesser, if it had been issued, would have been to create their own hypothetical scenario where they agreed that he was responsible for it, but they didn't agree that it was premeditated. And because neither party presented any evidence that would have yielded that outcome, it would be relying on speculation in that scenario. And so I think that given the evidence as it existed in this case, it would have been speculation to support a verdict on that. I see I'm well past.
It would have supported the verdict if there had been a second-degree murder conviction. You would be arguing that there was a sufficiency of the evidence, would you not?
I would, and I don't think
Right.
that's at all inconsistent because of the different standards. So yeah, again, I would agree with that. I don't deny that, but I think that we have to look at the issue as it exists and based on the appropriate standard review.
The different standards being the different perspectives used by the appellate court in determining whether a lesser included offense instruction was warranted, which is you look at it, the light most favorable to the requesting party, i.e. the defendant, versus if we're looking at the sufficiency of the evidence to sustain a conviction, it's in the light most favorable to the prosecution. Is that what your point?
Yes, exactly.
All right,
Yes.
thank you.
If there are no further questions, we would respectfully request that the defendant's conviction and sentence be affirmed.
Any more questions?
I do have one more question. I'm going to try and get you to talk about two cases in particular. First one, Haberline, which is the Dollar General killing from Bonner Springs, if you remember that one. And then the other one, I think it was Tahoe, where the guy had the high-powered rifle out behind an ex-girlfriend or ex-wife's house. And that one's made a repeat appearance recently. Would you say that those two are kind of the high water marks on no discretion on the part of the district court under the statute to refuse a lesser included offense instruction? And were those just wrong, or were they just the edge of the rule?
I am familiar with both cases. I haven't reviewed the evidence in those recently.
Haberline was especially brutal. It was a lengthy beating, dragging the victim back after she attempted to escape and continuing the beating that eventually killed her. If that helps you.
I think that I would agree that there is a fine line sometimes between whether something would be just at the end of the spectrum or if perhaps it would be a case where I would argue that the court's opinion was incorrect. And of course, all cases are so variable on their particular facts that I would argue that in this case, it would be crossing the line, that there would be no evidence supporting the lessers in this particular case. And again, the facts are just so variable. And I think that in a case like this, where you're looking at somebody who
Drives, reloads, etc.
Yeah, and especially when we know that I think the evidence supports a conclusion that he went to the restaurant in the first place knowing and that there was going to be, in all likelihood, some sort of a gang conflict there, and then probably already had premeditated before he even got to the restaurant. But certainly then after seeing one of his fellow gang members, his friend, get shot in the parking lot, that would further indicate that he formed the premeditation then to retaliate by going by and shooting up this house and this vehicle. So I think that even with those cases out there, I would argue that this would be even a greater extension and going even beyond those two.
And so the provocation, you just have mentioned a provocation being the shooting his friend, but you're saying the 6 to 10 minutes it took to drive was sufficient for a cooling off period that would negate a sudden quarrel or a heat of passion?
Certainly so, especially because I think that in the first instance, our argument, of course, also is that he was more than a willing participant in that initial combat at the restaurant, and so I don't think that would lend itself to a sudden quarrel argument anyways when you're an active participant in starting the proceeding that actually led to his friend's death. But yes, to your question specifically, I would argue that having 6 to 10 minutes is an appropriate amount of time where a reasonable person would be able to respond in some way other than firing 18 shots and killing another person.
And who makes that determination of the cooling off period? Is that a gatekeeping function also?
Well, in this case, nobody was asked to make that because nobody was arguing for.
Well, I understand that, but that goes to what we're talking about is when you have factual issues to resolve, credibility to assess. It's back to where we draw the line of the jury making that factual determination versus the judge.
Yeah, I do think that the judge has that role. I think in the case law talks about the factors that play into whether, in a sudden quarrel context, whether it would be an appropriate instruction, and it lists those various factors, including whether there's a cooling off factor. And I think that yes, the judge would have to be the one to make that. Otherwise, we could be arguing that somebody's entitled to a sudden quarrel or heat of passion for something that happened 6 or 10 years ago, let alone 6 or 10 minutes ago. I think that the judge clearly has to make that decision and look at the evidence and determine whether it would be warranted.
Any further questions? Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
Just a couple quick points. We talked a lot about the evidence and what it would support in this case and the overwhelming evidence of the premeditation. I think those are good arguments for a jury. But I also think the jury should have been fully instructed on the lessers, because even when you have overwhelming evidence, it's still a jury's decision at the end of the day. We covet the idea of a jury trial, and what the courts are doing, what the district court in this case did, was took away decisions from a jury.
Let's go to that discussion we had with opposing counsel a few minutes ago about the motion for a judgment of acquittal. If that is successful, that is taking the matter away from the jury, correct?
And that's a district court finding that there is no legal basis for the conviction.
Is that our standard for that?
I don't know if I stated it in the correct legal terms, but I would also state that that is a very low bar, whether or not it goes to the jury. The judge has said, is there a minimum level here? And if there is, it goes to the jury and the jury decides. So if you're looking at judge being a gatekeeper in that essence, he is, and he's using a very low bar. And I think the same low bar should be applied when we're talking about jury instructions. The judge can be a gatekeeper, and his job is to determine whether or not there is some evidence. That, again, is a very low bar. And if there is some evidence that would support that, possible lesser included, then it goes to the jury, and the jury makes that decision. Again, these are questions for the jury where there is some evidence to support the lessers. And clearly here there is evidence to support these lesser included instructions.
Your argument, in sum, as I understand, is that, and you just said this, that this took a question away from the jury.
I believe it did, yes, Your
My
Honor.
question is, on what basis did the jury have the right to get the question in the first place?
The question as to premeditation,
the question that was allegedly taken away from the jury. Why did the defendant have a right for the jury to hear that question in the first place?
I
This
think-
gets to the question I asked opposing counsel, which is where's this right derived from? Is it purely? My understanding is you're making a statutory argument, but you sort of are shifting into at least the lingo of a constitutional argument when you talk about taking a question away from the jury and so on.
And I guess I would say two things about that. I think the right does come from the Kansas statutes, which talk about some evidence. And I've made this argument to this court before, not successfully yet, but the right to have lesser included goes to a defendant's constitutional right to present a defense to a jury. We have many cases where the only defense at trial is, I'm not guilty of first-degree murder, it was manslaughter or second degree. So I think it does bleed over into the right to
But not on
present.
this particular one, not on the second degree intentional, because his defense was, I wasn't there, it wasn't me.
That was his defense as far as that, but I think the court has recognized that defendants can have inconsistent defenses. They can
But he
say,
didn't
I
have an
didn't.
inconsistent defense here, he had no defense that fits the lesser included you're saying he had a right to. I'm just saying that if, to the extent you're making a constitutional argument in this case, on that particular lesser included,
But
that
in this,
argument doesn't hold, does it?
but in this case, while he still argued to the jury, I didn't do the drive-by, his counsel still asked for those lesser includeds. So I think he does have that ability to make that defense and that right to do so. If there are no other questions, again, I would ask this court to reverse for the reasons stated in our brief.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.